Good afternoon, everyone. My name is Karen Harris, and I am the Illinois Health and Hospital Association's General Counsel. First, I'd like to welcome you to today's webinar entitled Litigation Concerns for Hospitals in the COVID Era. This webinar is being co-hosted by the IHA and the law firm of Shook, Hardy & Bacon. This webinar has been approved for 1 hour of continuing legal education. There'll be an evaluation form after today's program. Please make sure to complete the evaluation. At this time, I would like to introduce today's panel. Erin Boland-Hines is of counsel at Shook. Erin concentrates her practice in business litigation, class action and complex litigation, and privacy and data security. She also provides counsel to clients on employment-related matters. During the past 2 years, Erin's practice has focused on class action defense and compliance under the Illinois Biometric Information Privacy Act, or BIPA, litigation, including representation of both employers and timekeeping technology providers. Also with us today is Melissa Siebert. She's a partner and director of Shook's Biometric Privacy Task Force. Melissa concentrates her practice in complex class action litigation. She also leads Shook's biometric privacy practice, defending biometric technology users and providers in more than 60 BIPA class actions pending in federal and state courts. Melissa's experience handling Illinois Biometric Information Privacy Act cases has made her one of the leading lawyers in this rapidly developing area. In addition to her biometric privacy practice, Melissa has substantial experience representing employers in labor matters as both in-house and outside counsel. She has significant experience in FLSA and wage and hour class actions, as well as EEOC pattern and practice investigations and lawsuits. And last but not least is Peter O'Neill, who's an associate at Shook. Peter focuses on complex commercial litigation. His ability to simplify complex issues and provide cogent advice results in favorable outcomes for clients. His work experience spans diverse subject matter, including antitrust, class actions, post-closing dispute, and intellectual property litigation. He has litigated multiple matters to conclusion by dispositive motions and through trial or arbitration. I'd now like to turn the floor over to Melissa. Melissa, the floor is yours.
Great, thank you, and welcome everyone. The purpose of today's presentation is to focus on some emerging litigation trends in the wake of COVID-19 with respect to specifically hospital-related litigation. And that would include things such as recent retaliatory discharge lawsuits, lawsuits regarding visitor policies, and developing litigation, including challenges to Governor Pritzker's quote-unquote stay-at-home order. We're also going to be providing you with an overview of potential future COVID-19 litigation that we see on the horizon in the hospital healthcare context. Next slide. So our topics for today, first we're going to talk about some legal trends, and those include, again, the retaliatory discharge whistleblower PPE lawsuits that have currently been filed. And we're going to review some of those with you. We're going to talk about the policy-related lawsuits, about visitors and access, especially as many of us contemplate the return to elective procedures. We're also going to be talking about other trends, including increased union activity, some wrongful death lawsuits, and the court challenges. This is one of the first times that we've had to significantly change our slides, including as of yesterday, based on changes to applicable laws, executive orders, and the repeal of the Illinois Workers' Compensation Commission's emergency amendment. What you're seeing on the right are some of the laws, orders, and guidance that we're going to be discussing today in relation to these legal trends. The PrEP Act, Governor Pritzker's executive order, that's highlighted in red because, as I'm sure you're aware, it now faces perhaps as many as 3 challenges which have an impact on us that Karen will be addressing later on in the presentation. We're also going to be talking about the Illinois Hospital Licensing Act and some immunity that it might provide with relation to visitor policies. We're also going to, again, be talking about workers' compensation and the exclusive remedy of workers' compensation This is, again, also highlighted because, as you may well know, the emergency amendment was repealed on April 27, 2020, something we'll be discussing in more detail. And then we're going to talk about common law defenses, which still exist, especially in this ever-changing, constantly adapting legal environment.
Good afternoon, everyone. This is Erin Bowen-Hines, and I'm going to take you through the retaliatory discharge whistleblower lawsuits we've seen recently filed against hospitals. We'll start with the lawsuit filed against Northwestern Memorial Hospital on March 23rd. This was brought by a nurse who was hired through a staffing agency. She did not like the masks that were mandated by the hospital, and she sent emails about it, and then she wore her own mask, N95 mask. After her assignment was terminated, she filed a lawsuit bringing retaliatory discharge claims and a respondent superior claim. Then she and her counsel, the Blake Horowitz law firm, appeared on Dr. Phil and advertised the lawsuit in attempts to get more plaintiffs on to bring these types of actions, which brings us to the second whistleblower lawsuit we're going to talk about, which was brought by the same law firm. This was on behalf of a public safety officer. This plaintiff wanted to wear a mask, and he was a security guard, which would be probably interfering with his ability to communicate as a security guard and to be recognized as a security guard. He ended up not going back to work, and as a result filed a lawsuit with retaliatory discharge claims, respondent superior, similar to the prior lawsuit. The plaintiff's claims in this case differ to the extent that they're all based on a constructive discharge. We think that you'll probably see a rise in refusals to return to work in the near future, and this is probably fueled a bit by some inconsistencies with policies. We know that the IDPH has guidelines that say the facilities have to supply the PPE. And there's also the issue of bringing your own mask and whether that there's sterility issues with that. There also are some guidelines from accrediting authorities that contradict who has to supply the PPE. And that's probably going to fuel some more of these types of lawsuits. Which takes us to another lawsuit. This is the third one that actually was filed by a different law firm. Now we're up to April 14th. This was a hybrid of the whistleblower and FMLA claims because this plaintiff had a pre-existing condition. This complaint is also a little more advanced to the extent that there are several whistleblower statutes that the plaintiff is moving under. And she has the traditional Illinois whistleblower statute and also this Nurse Practice Act provision, which provides that no person shall retaliate against a nurse who reports unethical or illegal healthcare practices or conduct. There also is pending right now a proposed anti-retaliation ordinance in the city of Chicago. And that ordinance provides that no employer can retaliate against an employee staying home pursuant to a public health order by, for example, the mayor or the governor. And this complaint specifically also includes a Illinois whistleblower protection claim, which Peter is going to comment on.
Hi, everyone. So this is Peter O'Neill. Just to build on what Erin was talking about, she had mentioned that the complaints are becoming a little bit more artfully drafted. And here you can see that one of the basis for the whistleblower claims is 210 ILCS 86-35. And that comes, that's a provision under the Illinois Hospital Report Card Act. And the reason we can tell that the complaints are becoming more artfully drafted is because this specific whistleblower provision was recently in one of Governor Pritzker's executive orders that set aside many provisions of the Hospital Report Card Act, but it specifically called out this whistleblower section by name, saying that it would not be set aside along with the other provisions. So we're starting to see the plaintiff's bar starting to pick up on some of these exceptions that are in some of the executive orders and making sure they're trying to plead around things. So that's why that one's a little bit more artfully drafted. And now we're actually going to move to talk about some of the potential defenses to these types of lawsuits. Now, the first that we're going to discuss is the HHS Secretary's COVID-19 declaration, which was issued pursuant to the Public Readiness and Emergency Preparedness Act, also known as the PrEP Act. Now, the PrEP Act generally allows the HHS Secretary to issue a declaration to provide immunity to covered persons for claims of loss arising out of the administration to or use by an individual of a covered countermeasure. Now, that's a lot. We'll break that down shortly. But this law and the declarations issued thereunder have been used for other outbreaks, including Ebola, Zika, and H1N1. However, there's very little case law applying the statute or the declarations. Now, the HHS Secretary issued the requisite declaration on March 10th of this year. It's effective February 4th of this year through October 1st of 2024. And when we talk about covered persons, they include both 1, licensed healthcare professionals, and 2, program planners. Now, program planners include a person who supervises or administers a program with respect to the administration, dispensing, distribution, provision, or use of a covered countermeasure. And importantly, under this definition, a private sector employer can be a program planner when it carries out the described activities. So you can see that hospitals could qualify as covered persons if they were, quote, supervising or administering a program with respect to the provision of a covered countermeasure. Now, before we get into, administer and then covered countermeasure, because those are two defined terms as well, we have to talk about loss. Loss is defined in the statute as any type of loss, although that issue hasn't really been litigated. What that means hasn't really been litigated. The plaintiff's bar would almost certainly contend that this immunity only applies to claims of personal injury or damage to property. But the broad any type of loss language indicates that it could apply to other claims. Then when we talk about administration, somebody who's covered by the statute administering a covered countermeasure, that includes the physical provision of the countermeasures or activities and decisions directly relating to the distribution and dispensing of the countermeasures. And this includes management and operation of countermeasure programs, and this is important. The management and operation of countermeasure programs and the management and operation of locations for distributing countermeasures. And so we talk about the administration, and then we can talk about the covered countermeasures, which this definition has changed a little bit due to recent amendments, but covered countermeasure includes any antiviral, any other drug, any biologic, any diagnostic, any other device, any respiratory protective device, or any vaccine that's used to treat, diagnose, cure, prevent, or mitigate COVID-19. It's very broad. The original declaration that the HHS Secretary issued included products that could be considered covered countermeasures. They were products that could be subject to an emergency use authorization, which was issued by the FDA. You've probably seen news about these authorizations. One that's rumored to be coming out regarding remdesivir, the antiviral drug that's supposed to reduce the recovery time for those with advanced COVID-19. So that's the type of emergency use authorization that was part of the original declaration. But there was some confusion over whether things like face masks and whether NIOSH-approved respirators would qualify as covered countermeasures under the original declaration. So HHS amended the declaration on April 10th, and that now expressly includes as covered countermeasures under the PrEP Act all NIOSH-approved respirators. And in addition, HHS actually issued an advisory opinion on April 14th, noting that immunity would be extended if a party reasonably could have believed that the product was a covered countermeasure. So this was put in place to, it's essentially a protection that's built in for a party who innocently, for example, buys what they believe are NIOSH-approved respirators and a certain subset come back and they might be counterfeit or defective in some way. The HHS Secretary has indicated that they're going to broadly interpret the immunity provision to cover those folks who reasonably could have believed that the product they were distributing was a covered countermeasure. Now, there is an exception for willful misconduct built into the statute. So there is no immunity for willful misconduct, but the plaintiff must prove that by clear and convincing evidence. So it's a fairly high bar. But when you talk about taking all these definitions together, you can kind of see how there might be an argument that a hospital, which implements a policy for distributing PPE or N95 masks, for example, might be immune from claims arising out of that policy. And there could be an argument made that these retaliation and whistleblower PPE lawsuits are claims that do arise out of such policies. Now, we say might because there's very limited case law interpreting the Act or the declarations issued pursuant to the Act. So again, this is a relatively untested area of the law. Now, our next potential defense comes from Governor Pritzker's Executive Order 2020-19 in response to COVID-19. And I'm going to walk you through the immunity provisions of the order, and then I'll hand it over to Karen to discuss with you on the next slide some of the evolving and conflicting interpretations and guidance that's recently been issued with respect to this order. So the order was issued April 1st of 2020. It contains a broad immunity provision that applies to healthcare professionals and healthcare facilities, both terms broadly defined and would include hospitals. Other states have issued executive orders which don't expressly cover healthcare facilities, so Illinois is more favorable to healthcare facilities and hospitals in that respect. The order covers civil claims of injury or death. It does not define injury, so it might be read to apply only to personal injury or death. But there's also very broad whereas clauses in the order that indicate that its scope could be expanded to other types of injury. For example, one of the clauses states that ensuring the state of Illinois has adequate bed capacity, supplies, and providers to treat patients with COVID-19 is of critical importance. And so the argument would be that by providing immunity to hospitals for putting in place policies with respect to provision of PPE, for example, that serves the purpose of ensuring that the state of Illinois has adequate supplies to combat the COVID-19 crisis. And we think that argument would be further supported by the order's definition of rendering assistance, which is a prerequisite to immunity under the order, so that the facility must be rendering assistance to the state in its effort to combat COVID-19. And rendering assistance includes, and this is the quote from the order, measures such as increasing the number of beds, preserving personal protective equipment, or taking necessary steps to prepare to treat patients with COVID-19. So we have both preserving personal protective equipment written in there, or taking necessary steps to prepare to treat patients, which is very, very broad sort of catch-all provision toward the end. And note that the order expressly states that it's not intended to preempt any other type of immunity available. And so again, we see here how a hospital puts in place a policy for preserving or distributing PPE might be immune from claims that arise from such a policy. Now, one final note is that there are exceptions for gross negligence or willful misconduct, and the practical effect of that is that the defense, if it were asserted, it's not likely to dispose of these cases early, more likely to be successful at a later stage in the case if it ends up applying. Now, the order states that it's effective for the remainder of the duration of the gubernatorial disaster proclamation. As a result, if the disaster proclamation expires or is otherwise invalidated, the immunity under Order 2020-19 would also expire. Now, this is important in light of the recent challenges to the governor's most recent decision to extend the stay-at-home order through May. And so, Karen, I'd like to bring you in here and ask you to talk a little bit about these recent challenges to the order and what the IHA is doing for its membership with respect to some of these challenges.
Thanks, Peter. So with respect to the recent challenges, there have been 2 cases that were filed, and I'm just learning today that there may be some litigation introduced as well, some legislation introduced as well. So let's start with the first case. So Bailey v. Pritzker is a case filed by Representative Bailey, and basically he challenged the governor's ability to extend an order beyond 30 days based on the language in the Emergency Medical Agency Act. The case was heard on Monday in Clay County for a TRO. We actually filed, we being IHA, filed an amicus brief at the trial court level. It's very unusual, as many of you probably know, to file an amicus at the trial court level, so we weren't sure whether or not it would be accepted by the court. It was, however, in our opinion, they did not really look at our brief or give it much weight, because when you are issuing a TRO, one of the things that the court must do is weigh the balance between the remedies sought by the plaintiff and the harm that will be done to the plaintiff if you don't grant the TRO versus the public harm or other harm that would occur if you do grant the TRO. We feel that in this case, great weight was given to the plaintiff's claims, but no weight was given on the other side to the harm that will occur to the public because a TRO has been issued. Since that case, the governor's office and the attorney general office did file on the appellate level yesterday and also petitioned the Supreme Court to take up the case. The Illinois Hospital Association, along with ISME, the American Nurses Association, the Illinois chapter, and the Association for the Advanced Practice Nurses filed a joint amicus brief yesterday on the appellate level. We are waiting to hear right now from the appellate court or from the Supreme Court. In the meantime, a second lawsuit has been filed, this one by Representative Cabello. So Representative Bailey's case, the TRO that was issued is exclusive to him. So he's the only person who it applies to. He is not now covered by the executive order to stay home. However, Cabello's lawsuit is not only for himself, but it's for all similarly situated individuals, so basically all Illinoisans. We are waiting to see, that was filed in Winnebago, and we are waiting to see right now how quickly either the appellate court or the Supreme Court acts, because if obviously the Supreme Court acts, then more than likely, and says that they're going to be taking up the case, then more than likely the trial court in the Cabello case will just stay until they hear from the Supreme Court. So that's what's going on currently on the lawsuits challenging the governor's order. I did just hear this morning that another senator is possibly introducing legislation which would basically state that the governor can only issue executive orders lasting 30 days, and that if he wants to extend it beyond 30 days, this bill would require that the General Assembly vote to approve any extensions. So that's the bill that I think was just introduced this morning. I haven't had a chance to read through it yet, but that also may come into play. So I'll stop there.
And Karen, thank you. And just a couple other things with regard to the executive order. I know that IDPH and CDPH have issued guidance regarding elective surgeries, and that guidance might in some ways conflict with the executive order 2020-19. Can you just talk a little bit about that briefly?
Sure. So as you recall, the Executive Order 2020-19 basically says that, as Peter just explained, if you're rendering assistance on behalf of the state, then you are entitled to immunity protection so long as it's not gross negligence. However, one of the ways that rendering assistance is defined, at least in part for hospitals, is canceling electives in accordance with IDPH guidance. So the old IDPH guidance, as everyone knows, basically encouraged all hospitals to cancel elective surgeries and procedures in order to help conserve PPE, and most hospitals willingly did that. However, the new guidance that was issued last Friday night now allows for some elective procedures to begin again on May 11th, assuming that certain requirements are met first. So there's a slight discrepancy in sort of what's stated in the executive order, i.e. cancel all electives, and now we've got the new guidance that says, okay, you can proceed so long as you meet certain criteria. The way that we are reading that, and our conversation so far with the governor's office has been consistent with our interpretation, is that because the language says canceling in accordance with IDPH guidance, since the new IDPH guidance says that you can now proceed under certain criteria, so long as you are meeting that criteria, the liability protections under the executive order should still apply. Please note, however, that they apply only to your COVID-related activities. They do not apply to the elective procedures or surgeries that you're doing. Those would still be under a regular standard of liability, not the executive order's liability protections. The other kind of difficult part, especially for Chicago hospitals, is that CDPH, Chicago Department of Public Health, did issue an order as well. Their order says cancel all electives. They are aware that that sort of conflicts now with the new IDPH guidance, and we're anticipating before the May 11th sort of elective start date that CDPH will issue new guidance. So we will be working with CDPH and be on the lookout for new guidance from CDPH, hopefully to line up a little bit better with the new IDPH guidance and the executive order. I'll also mention that the executive order itself was set to expire today, I believe, so hopefully that will be extended as well.
Thanks, Karen. And finally, we've got the proposed legislation I know we were discussing. Can you talk just briefly about what IHA is doing to work with other organizations to maybe implement some statutory protections with respect to hospital activities?
Sure. So as many of you have been following along, we got the executive order several weeks ago, but because we anticipated, and now has occurred, that there's always the potential that an executive order could be challenged, we also made a request to the majority leaders in the General Assembly that they consider enacting legislation providing for administrative, civil, and criminal liability protections. We have not heard back yet about whether or not they're going to be doing that. As you know, the General Assembly is not in session and probably won't be in session until closer to the end of May, but that request has been made. Specifically, we asked that they look to New York. New York also issued an executive order similar to ours, and then they backed it up by enacting pretty broad-based liability legislation. And so we've asked them to proceed along the lines as New York did. So as soon as we have more information about that, we'll also let you know.
Great. Thank you, Karen. And now we will turn it over to Aaron, who will talk a little bit about some defenses to common law retaliation claims.
Thanks, Peter. Going back to those lawsuits that we discussed earlier, bringing retaliatory discharge and whistleblower claims, the common law defenses that we also have available to us include the requirement that the public policy, not only does it have to be identified, but the source must be specified. Now, in Illinois, that does include safety regulations in addition to statutes, judicial decisions, but the allegation must be that the discharge violated the public policy that was clearly mandated. We also have, we can't have individual grievances as a basis to a retaliatory discharge. And we also have the defense in Illinois that independent contractors cannot assert those types of claims. In addition to that, one of the cases had an FMLA claim as well, and the defense of the honest belief can be asserted in that the plaintiff was misusing their FMLA. So these are the common law defenses that we cannot forget about.
And folks, this is
Next slide.
One of the things that, hi everyone, this is Melissa Siebert. One of the things we want to stress to you as we're looking at all this ever-changing law is that some of the basics still apply. And it's going to be difficult for retaliatory discharge PPE claimants to say that they're backed by the public policy of Illinois, so long as the public policy of Illinois and federal policy includes these important immunity protections to hospitals to decide how to distribute and when to use PPE, particularly N95 masks, and how to effectively treat patients and who treats those patients and who has access to that PPE with respect to COVID-19 during this pandemic. So these common law defenses still exist, and they're valuable ones to you in the event that you receive one of these retaliatory discharge whistleblower lawsuits. Next slide.
Thanks, Melissa. Now we're going to talk about visitor lawsuits and potential defenses. This was a lawsuit that was filed down in Atlanta, Georgia, in the federal court against Emory Healthcare. Our law firm, Shook, Hardy & Bacon, actually represents Emory Healthcare in this litigation. The plaintiffs were at the hospital for a prenatal visit, and they have brought this lawsuit and included discrimination claims in addition to violations of the policy where they were escorted out of the hospital. The plaintiff actually is representing himself and his wife pro se. Now we're aware that this is not a well-pled complaint because the visitor policy that it's based upon is for an inpatient, and the plaintiff in this case was an outpatient. They were just there for a prenatal visit. We also saw in this complaint allegations of state actors, which we anticipate you could be seeing in complaints against public hospitals. We also know that very recently there's the newest IDPH visitor policy could be creating some issues for plaintiffs because they're requiring visitors to be tested for COVID in addition to the patients. So that's something that you could expect to see. There we go. And then this is a lawsuit that Melissa is going to talk about that was recently filed down in Texas.
Sorry. What we're starting to see is you just saw the first visitor policy lawsuit. That's the Emory lawsuit. And that includes all kinds of allegations, including discrimination allegations because the plaintiffs are people of color and that they were somehow discriminated against by the husband not being able to attend his wife's prenatal appointment. Degator, I hope I'm saying that correctly, is a recent filing in state court in Harris County, Texas. That was just filed this week. And what it claims is that the parents of a child who is hospitalized for non-COVID related reasons are challenging the one visitor at a time policy in the ICU that was put in place in part because of COVID-19, but also based on their operations in the hospital. They're challenging everything from whether single-parent medical consent is sufficient to the hospital's refusal to implement advanced directives and code status requirements requested by the plaintiffs. As you could tell, plaintiffs are also pro se. This is another example of an attorney representing himself. The hospital already has outside counsel. That counsel has clearly been interacting with these plaintiffs because they're named in the complaint just as a factual allegation. And things apparently got so contentious that the hospital discontinued the father's visitation rights. So this is an interesting case because it's based on the right to bring the claim is based on the child's status as a Medicaid recipient. And it's a more complex attempt, frankly, to try to bring a policy challenge. And you can see what they're doing is asking for injunctive relief to be allowed to implement their own standard of care procedure, their own care plan, and to prohibit certain hospital personnel, including the director of this unit, from interacting with them. And no medical personnel are allowed to inquire about code status. The request for a TRO was denied the day that this case was filed. The case does not go away, but it's an initial indication to us that the judge was not going to put this kind of a prohibition on a hospital as far as care. The other interesting part about this case is the status as a Medicaid recipient. As you know, there have been some waivers, some Medicaid waivers, and one of the things that has been waived during COVID-19 is the Patient Bill of Rights, certain provisions of the Patient Bill of Rights. That's actually 42 CFR section 482.13 that you see right here. So at the end of the day, we don't believe that under the current environment with the waivers that this claim is going to succeed. But again, as you saw in the retaliatory discharge cases, plaintiffs are getting more sophisticated at trying to challenge policies. And we do anticipate that you will get some more policy-related lawsuits as you start and begin elective surgeries. Next slide.
These are some of the defenses that we could assert to these policy lawsuits. The IDPH guidelines for visitors and visitors access could provide a basis to some defenses. In addition, Illinois, we have the Illinois Hospital Licensing Act. This might be a long shot because it actually has not been tested against a policy, but it's out there, and it should not be ignored. We also have the executive order that, for the same reasons we would assert it against the retaliatory discharge cases, for the basis of there's some broad immunity language. For example, under the rendering assistance definition, it allows hospitals to take necessary steps to prepare treatment for patients with COVID-19. And then, of course, we have our common law and statutory defenses. Common law defenses to discrimination, such as a policy that all visitors are treated the same, that is reasonable under the circumstances, a history of the facility having a policy on retaliatory discharge or discrimination claims, and that the language in the policy is broad enough that it would be covering any type of injury because it was written prior to COVID.
So if I may jump in here for a minute, when we're talking about the immunity under the Illinois Hospital Licensing Act, that's an entirely, probably a different concept from what you're used to considering that act. That act applies to decisions made by your various committees. And you could see where you would have your policy, your visitor policy right now, reviewed by all types of practice committees in order to ensure that you're adequately both reflecting the ever-changing guidance and regulations, but also that you're providing an environment that you feel is appropriate to have both COVID-19 care ongoing and also elective surgeries ongoing. And what we're saying is that if you implement that policy after appropriate review, it could allow you to claim that you're immune from suit based on the policy itself. And as Aaron was stating, as a longtime employment defense attorney, I can tell you that, again, it's going to be difficult for an individual like you saw in that first case we just looked at to claim that your visitor policy is discriminatory if it's applied consistently, regardless of color or background or anything else. And so I think the challenge for all of you is going to be to ensure that there's consistency. And you see that even in the Texas case. One of the allegations is that sometimes the father was allowed in for as a second visitor and sometimes he wasn't, making it seem, arbitrary. And so for your policy claims, always go by the adage that no good deed will go unpunished. If you make an exception, it will likely be used against you.
Thank you, Melissa. Now, potential policy-related lawsuits. We just talked about the lawsuit in Texas. The resources should be guided by crisis standards, but we are seeing challenges to that. And the crisis standards arguably could be used as a basis for immunity. And we haven't seen that. And I'm going to just toss it to Karen if you have any comments on that defense.
Can you hear me?
No, we can hear you.
Okay. Sorry, couldn't get off of mute there for a second. With respect to crisis standards of care, so as everybody I think knows, IDPH issued crisis standards of care a couple of weeks ago. If you looked at the crisis standards of care, it is a framework for hospitals to consider as they develop their own specific crisis standards of care policies. We did speak with the IDPH about it prior to it being authorized and issued. We had requested somewhat of a more prescriptive type of policy where it really gave specific guidance. The thought behind that was that if everybody is developing their own different crisis standards of care, there could be inconsistencies which could then result in more lawsuits. IDPH felt that it was more proper for it to give more general guidance, hence the guidance that was issued. And so it's what we have right now. So what I would say is, try and stay within the guidance and be able to reflect back that you took into consideration some of the items or ideas or concepts that are mentioned in the guidance as you develop your own crisis standards of care, because I think that'll be important should we get to a point when crisis standards of care need to be activated, that you can reference back and show that you were able to stay within that framework. I'll stop there. Thanks, Karen.
With regard to elective surgery visits and related lawsuits, well, Karen already commented on the confusion that we've seen between the IDPH and the CDPH guidelines on elective surgeries. We also know that there's a guideline for COVID 72 hours in advance testing prior to a procedure, which leaves open the possibility of the person contracting COVID between the test and the time of their procedure. We also have seen some challenges to visitor policies with service animals, and these have raised issues such as whether service animals can be restricted, what kinds can be restricted, and will this restriction violate other laws such as discrimination or disability. And Karen, do you have any experience with that recently in Illinois?
Yeah, so actually I did speak with Downstate Illinois Hospitals Council, who specifically raised the issue of service animals. So if you look at a lot of the CDC guidance and even the IDPH guidance that just came out regarding elective surgeries, one of the things that it's still trying to do is to limit the number of individuals who are coming into the hospital who do not have a specific reason to be into the hospital at that point. So that's one of the reasons that we're testing patients. If you look at the IDPH guidance, it also requires testing of visitors. So we're trying to reduce the number of people in order to decrease the potential spread of COVID-19. So the question was whether you could deny access to service animals. And in particular, downstate, the question was raised because some of the service animals that they see are not just dogs, but small farm animals, including a small pony, which I could not believe, but apparently is the case. And so, what policies can you put into place to restrict service animals? I did put the question to IDPH's general counsel. She has not gotten back to me on that yet. However, I do think that when you combine sort of the IDPH guidance about elective surgeries and still trying to contain the spread and limit visitors, as well as some of the CDC guidance, there could be an argument that you could make that service animals could not be permitted, but I do think if you went that route, you would need to then make some accommodations for how you're going to handle people who might otherwise need that. So, for example, if it's a service dog for a blind person, how are you going to arrange for that person to be able to navigate safely through the hospital without their seeing eye dog, and those kinds of things, and where do they leave the seeing eye dog? For example, the downstate hospital has arrangements with a vet nearby where the animal can be sheltered for a couple of hours while the patient is in for their procedure, and then the animal brought back to them as they're ready to leave the hospital after their procedure. So just some things to think about.
Thank you, Karen. We also want to bring up waivers to patients' rights. For certain hospitals that are considered impacted by widespread COVID, they are not required to meet written policies or procedures on visitation or patients who are in COVID isolation and quarantining processes. And that's under the Section 482.13 of the statute. And next slide.
Great. So we know we want to leave some time for questions. So we may speed up a few of our next slides, if you don't mind. Next slide. Great. This is just an example of some of the trends that we're seeing. One is that a New York State Nurses Association has filed several cases on behalf of the nurses and its unions against hospitals and against the state or the county, seeking to basically say that, hey, we weren't adequately provided PPEs and other protective measures during the COVID-19 crisis. I bring this up only as an example of what we know to be the case, is that unions, as they have a right to do, continue to advocate quite strongly for the rights of their members during this crisis. And we do see some increased union activity. We also see great collaboration. As Karen mentioned, the amicus brief that was filed, the nurses associations joined in that brief as co-amici. So our point in raising this is to remind you that communicating to your employees what you're doing and why you're doing it, and communicating with your union representatives as to what you're doing and why you're doing it is very important at this time when there's a lot of uncertainty on everyone's part. Next slide.
And this was one of the first wrongful death cases filed in the country related to COVID-19. It might have been the first, and we won't discuss this much since it doesn't involve the healthcare context, but it involved a Walmart employee who died from complications associated with COVID-19. And you're likely to start to see similar cases filed on behalf of plaintiffs working in, for example, meat processing plants, things like that. We've seen a lot of that in the news lately. And although we haven't seen a wrongful death case filed by a healthcare provider in Illinois yet, it's certainly not out of the realm of possibility, which brings us to the next case, which was a case that was filed by the executor of the estate of a deceased nursing home patient. The defendants were the nursing home and the executive director. The patient contracted COVID-19 in the nursing home and died. The allegations are that the nursing home failed to restrict visitors, in addition to failing to provide PPE to staff to prevent spread. And so here we see somewhat of a contrary argument to the visitor policy cases, because here the allegation is that the nursing home should have implemented a policy similar to the ones that are being challenged or will likely be challenged in some of the visitor policy cases where they're restricting access and things like that. Now the complaint also alleges that since March 26, 15 residents have died, 34 staff have contracted COVID-19. So as you've seen in the news, a number of these nursing homes were heavily impacted. So we could certainly expect to see these kind of lawsuits going forward. And we expect that these visitor policies will continue to be a recurring issue within these lawsuits. And then just talk briefly, we've already talked about the challenges to Governor Pritzker's executive orders. Quickly, with the Illinois Workers' Compensation Emergency Amendment, you've probably all heard about this, but the amendment would have provided that for any first responder or frontline worker whose injury resulted from exposure to COVID-19, the amendment was an amendment to the rules of evidence in workers' comp proceedings, and it basically would say that the exposure to COVID-19 would be rebuttably presumed to be causally connected to the hazards or exposure of the worker's employment. So that rule would have applied to healthcare workers, but also a broad range of employees in essential businesses. The amendment would have effectively eliminated the employee's burden of proving causation. And I say would because the rule was repealed quickly on April 27th. There was significant opposition from the business community, and there was also a temporary restraining order which was entered last week by a judge in Sangamon County, which prevented the rule from going into effect. So we just note this to sort of show that these things are constantly evolving. Again, as we put together these slides, it seemed like the law changed a handful of times. So just want to make sure we're staying on top of all the most recent updates, and we can expect these kinds of court challenges to continue going forward.
We just want to remind you that in addition to the guidance from CDC, IDPH, CDPH, there's also guidelines for OSHA and EEOC that are helpful, and that you should go to their websites and use that as guidance. Next slide.
And so thank you, everyone, for participating today. Before we take some questions, I just wanted to note that this program has been approved for 1 hour of CLE credit in Illinois. We ask that you please complete the speaker evaluations. You should be able to access them via the On24 platform, which you're all on. And an evaluation should also pop up when the webinar ends. And with that, with the little time we have left, we might now be able to answer some of the questions that have been submitted.
Sure. And so our first question comes from Roger Gustafson at Swedish American. We have an employee who has lupus and is refusing to come to work as her role as an RN, claiming she has a high risk for COVID, claims ADA discrimination, and for our rejecting FMLA benefits. RN not able to work around any other people, she claims. Any thoughts on handling this?
This is Melissa. That is, you basically gave us the next, like a law school examination there, folks, right? And I say that jokingly, but also in all seriousness. This is exactly the kind of claim that we think you're going to be seeing, and it's very similar to that lawsuit that we showed you about the nurse that had asthma that objected to not having the right PPE and the pressurized room, that she was at a greater risk for COVID. Remember, basic ADA and FMLA law still applies, meaning she still has to qualify for FMLA leave, including the CARES Act leave, if that's something that she qualifies for. She still has to show that she's requesting a reasonable accommodation. And from the sounds of it, refusing to work around any people at all is not an accommodation that you as a hospital are required to provide. She can't perform the essential functions of her job if she cannot work around any other people. This does raise an interesting question about your RNs that do have pre-existing conditions and how you're going to attempt to accommodate those individuals and whether you need to accommodate them in light of that disability. I would say this is one I would approach very cautiously and would be happy to talk to you offline about some ideas we have with respect to the allegation of lupus and the connection to COVID. We'd need to know a little bit more about your particular hospital to be able to talk to you in more detail about those, about our thoughts on that. But again, what I would say, folks, is common sense hasn't totally been thrown out the window. It's just that these lawsuits have arisen and they create on their surface some very sympathetic plaintiffs, which would be the same point I would make about the service animals. Agree that we need to be cautious about service animals, but we also see you're fighting somewhat of a PR challenge when you're not allowing, for example, visually impaired patients access with their dogs to receive elective surgery. That could be a PR nightmare for you. And as you saw from the first case we looked at, it's not a far reach for nurses, the quote-unquote hometown heroes of COVID-19, to get invited on Dr. Phil to state their claims in the press, whether those claims are true or not.
Yeah, and this is Karen again, and with respect to sort of employees at a higher risk for COVID, I have talked with some hospitals who have sort of gone through and designated some high-risk categories and thought about how they would make accommodations for those high-risk categories. So people who have underlying conditions, who may be over 65 years old, those kinds of categories, and so that ahead of time, so that when they're approached by an employee who may fall in one of those categories, they know how they would handle it. So that might be something that you want to think about, doing that exercise and figuring out if there are accommodations for those types of specific classes that you might want to make. So far, that's our only question, and we are now at the 1 o'clock hour. I do know that everybody is very busy, so we will end here. But if you do have further questions, feel free to reach out to me. My contact information is readily available, or you can feel free to reach out to any of our presenters today. I'd like to thank Shakardi and our presenters for this great presentation. Unfortunately, I think all of the information that was discussed is new, and we're going to see many more lawsuits, and we'll probably have to have another session like this as things continue to develop. So thank you, everyone, for your participation today. Thank you to our presenters. Please stay safe and healthy.